See, Brandon has joined us. It's great. So this panel is about, roundtable is about pretrial agreements in the US, Germany, and Japan. And it's such a hot topic, not just in these jurisdictions, but all over the world. It's such a fascinating story, although I don't think we'll talk a ton about the history today, but it's a fascinating story, the way this thing kind of organically grew up in the US system a long time ago. And now it's spreading around the world like some kind of invasive species. But some of us think that this is a useful legal tool. Others are skeptical of it. There are many different ways to design the idea of criminal settlements with firms. And the US has experimented with a number of different methods. Other countries are experimenting with some of their own methods and variations on this. And there's no doubt in my mind that the comparative exercise, which is so interesting and fascinating for all of us in the field, is also going to produce some very valuable data and conclusions and information as we continue to experiment. And it won't shock me if we end up at a point at some point, despite the US's attitude that it invented the entire field of corporate crime, that the US might adapt its own system in ways as it reflects back on the experience overseas. So a great topic, and our panelists today, this is the order we're going to go in. So we have Michael Levy, who's a partner at Mayer Brown, a deep experience in white collar. Michael and I go all the way back to the Enron case, a distant memory at this point. And he's going to talk about the US system. And then Brandon Garrett, who's a professor of law at Duke and the director of the Wilson Center for Science and Justice at Duke Law, my colleague and friend, is going to comment a little bit on the US system after Michael's remarks. And then we'll hear from Daniel Weiss, who's a partner at Hengler Muller in Frankfurt, Germany, about the German perspective. And I may offer some comments after that. And then lastly, in sequence, we'll hear from Hiroki Sasakura, who's a professor at Keio University Law School, to talk a little bit about what's going on in Japan. And as moderator, I'm going to really try to limit each of these segments to 15, 20 minutes at the outside so that we have time for Q&A from others who are in attendance at the conference. So Michael, take it away.
Thanks, Sam. Daisuke, if you can go to the next slide. First of all, thank you for inviting me to participate in this, and thank you for staying up all night in Tokyo to make sure that this conference goes off well, and thank you for getting me a chance to reunite with Professor Buell, who I probably haven't seen in close to 20 years. Just briefly in terms of background, after clerking for Lewis Powell on the Supreme Court and working briefly in private practice, I was a White House fellow and then a federal prosecutor in Washington, D.C. at the U.S. Attorney's Office there, and then have been in private practice for about the last 20 years, mostly representing companies and individuals in a wide range of white-collar matters, many of them involving highly complex financial, tax, and accounting matters, and lots of them having an international dimension to them. So that's my background. As much as I would like to engage right away in some of the fascinating issues that Sam talked about, I think for purposes of an international crowd, it's going to be important to sort of set up the basics of how the US pretrial agreement system works. And so the first thing I wanted to set out really are what are the options that the Department of Justice has at the end of one of their investigations in terms of how they're going to deal with a company. And the reason this is important is because, as others have mentioned, in the US, a company is criminally responsible for every act that any employee anywhere in the company engages in, as long as it's within the scope of that employee's conduct. And that includes employees doing exactly the opposite of what their supervisors have instructed them to do. That's still conduct that the company can be responsible for. And so it's important for prosecutors to exercise discretion in determining not just when a company can be prosecuted, but when it should be prosecuted. And so these are, when the investigation is over, there are a variety of different options, and these 5 are laid out. The first one is a declination. They simply decide that they are not going to go forward. You call up your client, you pop up at a bottle of champagne, and you celebrate. Not much to discuss there. The next three are all forms of a pretrial resolution. They all differ in important respects, but all of them will have some kind of a public announcement by the Department of Justice about the resolution. And the government will require companies to do some among a various list of possibilities: paying a fine, paying restitution to victims, disgorgement of gains, improving their compliance programs, taking other actions to make sure that this doesn't happen again, like firing the wrongdoers who are involved. Oftentimes, they will involve a self-reporting obligation. So during the period of the agreement, the company agrees that if it discovers any other wrongdoing, it will report it to the Department of Justice. And very controversially, the appointment of a monitor, although that's become less frequent recently, may become more frequent under a Biden administration. The first is the non-prosecution agreement, which doesn't involve any charges being filed in court. It's basically a contract between the government and the company. If the company breaches the contract, the government can file the charges in court. That's the stick to comply with the agreement. I did not put in here the so-called declination with disgorgement that's been discussed, because I really think a declination with disgorgement is just a non-prosecution agreement where the terms have already been fulfilled. There's nothing else really to do, so there's no need for ongoing obligations. It's done. It's just a statement is, we've decided to decline this prosecution because the company's done these things. Next is a deferred prosecution agreement, which is filed in court. And so it's a company with a criminal complaint. The company will agree in court to the facts that are set out in the complaint. If the court approves the agreement, the matter is then deferred in court, usually for a period of years, however long the DPA lasts. And as long as the company satisfies the terms of the agreement, at the end of the term, the government moves in court to dismiss the case, and there's no conviction. Then the guilty plea, which is the next step, again, filed in court, criminal complaint. There's a plea agreement which sets forth the terms by which the company is agreeing to plead guilty to a charge and what things the government agrees not to charge it with. Company not only agrees to the fact, but pleads guilty and proceeds to sentencing. Most of the time, the plea agreement has a specific negotiated sentence involved in it, so that the judge will either have to approve it or disapprove it, all or nothing. And important to note for these purposes that guilty pleas have collateral consequences, the most important one often being debarment from doing any federal contracting. So you don't necessarily have that problem with the DPA or MPA. You do have to deal with it in a guilty plea. And the last possibility is, of course, the company can fight the charges, get indicted, and take the case to trial. Ever since Arthur Anderson, prosecutors have had enormous bargaining power in these negotiations because companies have been very afraid to take a case to trial, and so that's a pressure that that can really impact the balance in these discussions.
Sorry, Michael.
Yeah.
Jumping in. So, could I ask a question? And so I appreciate it if you could clarify the relationship between prosecution and indictment and complaint. So this terminology are really important to understand these category of plea agreements.
Yes. So an indictment is a formal listing of the charges and the specific conduct that it's involved and the specific offenses that the company is accused of having violated. And it is done through the grand jury. A majority of the grand jury votes to issue the indictment, and that is the charging document. The criminal complaint is just a different version of a charging document. It doesn't have to go through the grand jury, and that's what usually happens when there is an agreed upon plea agreement or DPA. So you don't need to go through the grand jury process to get the charges. And a prosecution is just, I think, a general term for what the Department of Justice does. It prosecutes cases. That includes investigating, it includes resolving, it includes trying cases. Those are the three terms, if that's helpful.
Okay, thank you. So especially in Japan, so there's no such two-phase procedure in criminal procedure. So it's better to understand these terminology clearly. So thank you so much.
Oh, no problem. If you need me to explain anything else, feel free to ask.
Thank you.
Maybe go to the next slide, which I'll just touch on briefly. And I wanted to touch on this just because we'll spend more time talking about the factors that the Department of Justice requires prosecutors to consider and weigh when they're talking about a corporate prosecution. But it's important to note that prosecutors are also instructed that they need to decide first whether or not this is a case that they would bring against any person. And there's an important initial threshold, which is that there has to be admissible evidence that's probably sufficient to obtain and sustain a conviction for a federal offense before they should go forward. That's actually not set forth in the part of the Justice Manual that talks about the factors, but it's important because you really need to have sufficient evidence. You need to have a likelihood of success in order to bring any kind of a case, including against a company. The other standards are really very much mirrored, I think, in the factors for corporate prosecution. The only thing I'll note is that if the person's subject to effective prosecution in another jurisdiction, in this part of the Justice Manual, there's an explicit recognition that sometimes foreign jurisdictions have a very strong and sometimes even a stronger interest in prosecuting than the Department of Justice may have. And in situations like that, if the foreign jurisdiction can effectively prosecute and the penalties are significant, then that is a factor that the Department of Justice has to take into account in any kind of a prosecution, including corporate prosecutions. So let's get to the next slide. These are the now 11 factors that are listed in the so-called Principles of Federal Prosecution of Business Organizations in the Justice Manual, which is the policy manual governing all DOJ prosecutors. And again, the idea here is what standards and what factors, in addition to the ones that you would think about for a human being, should be taken into consideration when you're talking about a company and whether or not to indict and prosecute a company, because a company can't be thrown in jail. There are shareholders who will suffer who didn't do anything wrong. There are lots of considerations like that. I generally group these into three sort of categories. The first three are all based on conduct that's already occurred by the time the investigation has happened. It's what happened in the offense itself and what's the company's history with respect to criminal conduct. The next four are really things that the company can do after the alleged criminal conduct's taken place that can influence the government in deciding whether or not to decline rather than an NPA or DPA rather than a guilty plea. And the last four are really, I think, in many respects, more technical consideration that relate to how particular types of resolutions can impact or impact the company or have other consequences. So just to briefly go through these, just to give people a sense of what they are. The first one is probably the most important. It's the nature and seriousness of the offense. There's a real focus on risk of harm to the public. Is this a significant thing that warrants the use of federal resources? And part of that is the applicable DOJ policies and priorities, which really ought to be its own factor. But it basically deals with the fact that some components of the Department of Justice, like the Antitrust Division, have their own approaches to corporate investigations. So the Antitrust Division, as you may know, has their leniency program, which provides full amnesty for the first company in. It's very much a threshold. So basically this says antitrust can deal with it that way. The rest of the department will deal with it this way. Pervasiveness of wrongdoing is an attempt to get at this idea that not every single thing that any employee does within a company should result in a criminal prosecution of the company itself. And the idea is, on the one hand, you can have an isolated act by a single employee, and that act may be directly contrary to what their boss told them to do. On the other hand, you can have a lot of employees all engaged in this similar behavior, all of which is condoned and in fact sometimes even encouraged by management. Obviously, in the first situation, you're going to lean toward not prosecuting the company, just prosecuting the individual. In the other situation, you're more likely to prosecute and indict the company. And the last one is basically the equivalent of a corporate criminal record. Has the company done this before? Has it learned from its mistakes, or is it just repeating its conduct? The next sort of set of categories, willingness to cooperate, is something that has gotten a lot of focus and attention because it's something that, as I said, is within the company's ability to control even after the act has occurred. It's something that the government has very much pushed and emphasized with corporate resolutions. The government, to greater and lesser extents over the last two administrations, has really tried to focus cooperation credit on leveraging that into getting information about individual employees so that they can prosecute individual employees. So they're trying very much to use this as a mechanism to get individual accountability. Adequacy and effectiveness of compliance programs. I think earlier there was a discussion of the DOJ trying to set out factors in considering what is and isn't an effective compliance program. What's interesting here is when these first started, it was really, did you have an effective compliance program in place at the time of the offense? It's now expanded to, do you have a compliance program that's effective in place at the time of the charging decision? So that, again, gives you as a company an opportunity to implement a more effective compliance program by the time you start sitting down and talking to prosecutors about what they should do with the case, to sort of emphasize to them that you've learned from your mistakes, made sure it's not going to happen again. Voluntary disclosure, critically important, part of the risk and reward trade-off that companies make all the time. If they find out about something, do they go to the government and tell them about it, get credit for it, but potentially might be something the government doesn't ever find out about and nothing would ever happen? On the other hand, it's something the government might find out about through whistleblowers, or they might find out otherwise. And if they found out that you knew about it and didn't disclose it, they're going to take it that much more seriously. Remedial actions is not just restitution, but it's efforts by the company to make sure that this doesn't happen again. So improving compliance programs, firing wrongdoers, or otherwise disciplining people who were involved, and making it clear, sort of sending a message to employees that this kind of conduct won't be tolerated. I think, for sake of leaving time for questions, I'm going to drop the last four. Anyone's welcome to ask me about them if they want, but I want to make sure there's enough time for others to speak and to ask some questions.
Thanks, Michael. So, Brandon, I think we'll turn to you for some comments now, and particularly focused on the issue of pretrial agreements. Anything you want to say to kind of expand on what Michael talked about, or complicate things in interesting ways? Go ahead.
Sure. I'm going to share my screen for a second. See if this works. Looks like it won't work. That's fine. Well, thank you, Jessica, and all of you for being here and for organizing this conference. I want to just expand a little bit more on what we can learn from the large body of corporate prosecution agreements that we have in the US. You know, in Japan, you have, what, 3 so far under the new plea bargaining settlement system. So it's a really early practice. And, you know, I maintain a corporate prosecution registry as a scholar, along with some former colleagues at the University of Virginia. It's a joint Duke and UVA project. We just made a big update to the website, so I'm looking at it now. We have 4,275 agreements contained on the site, and it only goes back to, for the most part, 2001. And so in 2 decades, it's, you know, more than 4,000 agreements, with just a handful of agreements that we included from the 90s. There are a lot of variations among countries in terms of how accessible or how well maintained court dockets are, and how transparent government agencies are about settlements that they reach with entities that aren't in court, where nothing is filed in court. And to be sure, for some of the types of agreements that we've talked about that are mostly out of court, like non-prosecution agreements, sometimes, the thing that the company and the prosecutors most prefer is to not have that be made public and not have all the terms shared with members of the public. We're actually in the midst of another round of Freedom of Information Act litigation with the Department of Justice to secure additional agreements which are out there, but where we don't have the text of the agreements. For the most part, though, in the US at least, there is a strong understanding and recognition among prosecutors that it serves the public interest to have the details of a settlement with a corporation shared, even if it's not something that's filed in court. And it's something, it's an accomplishment. There's a public interest in explaining what happened in a corporate case. Just to give a sense of what these agreements look like, there are a lot of similarities in terms of the terms of the agreements and the types of sections that they have and the things that they say, whatever the label is. So Michael wonderfully described all the different types of agreements, but whether it's a non-prosecution agreement or a plea agreement or a deferred prosecution agreement, and the vast bulk of these are plea agreements where there is a conviction entered in court. That said, more of the cases involving large public companies tend to be these deferred and non-prosecution agreements. Anyway, the terms are often quite similar. Certainly once you start heading towards declinations or non-prosecution agreements, there may be fewer things that the company is required to do going forward because they've already substantially complied. But in general, these agreements begin by saying some things about why did this company get the deal that it did? What were the considerations that prosecutors took into account? Why did they receive a relatively more lenient or more serious outcome? What were the factors that were considered? And sometimes with explicit reference to some of these prosecution guidelines that seem to change with every new deputy attorney general at the Department of Justice. I'm sure we'll have some new guidelines, in the first 6 months of next year. There will then be some sections describing what were the crimes at issue. Occasionally you'll see an agreement where they actually won't say what the crime is, but that's kind of odd. They'll describe what the basic elements of the conduct were. They will talk about whether the company accepted responsibility, what form of cooperation the company provided. The agreements will describe what dollar amounts were involved and what dollar amounts are appropriate for some kind of a fine or other type of payments. Increasingly in recent agreements, you may see not just a sentencing guidelines calculation. This is the range that would be possible under the United States sentencing guidelines, but also description of payments made to other prosecutors or regulators around the world. And typically acknowledgement that although there's no formal double jeopardy as between countries, US prosecutors will typically say, look, if you already paid $1 billion to French authorities, you don't have to pay that here. We will set that off from your fine. And so there may be a quite lengthy discussion of how these dollar amounts are calculated, what are the different considerations, and what types of payments there are. There may be a fine, there may be some type of forfeiture, there may be payments to regulators that are credited, payments to other folks. There may also be community service payments or obligations. Then there will be sections describing what types of non-monetary things the company is expected to do. These agreements last for some period of time. They tend to average between 2 and 3 years. And that said, there's sometimes cases where the company has been investigated for some time already and they've already made the changes that prosecutors want. But typically the agreement is in place for some period of time. And during that time, the company is expected to make some further progress on improving its compliance, on changing its policies sometimes. And so there'll be a description of what changes the company has agreed to make, has already made, or will be making. In some cases, there is a monitor appointed to oversee some of this work. And there may be a separate section or addition to the agreement which sets out the duties and responsibilities of a monitor. It's increasingly become the practice to have a work plan and something quite detailed explaining what power the monitor has, what the scope of the monitor's duties is. As someone who's now doing monitoring, I very much appreciate the importance of having the duties and responsibilities of a monitor set out in advance. The agreements will talk about what happens if the company doesn't cooperate or comply and what the consequences of that may be. And there's often a portion of the agreement which sets out in varying levels of detail what actually happened, some kind of a statement of facts. Often it doesn't name names. They'll refer to, manager A, supervisor B, deputy vice president C, but sometimes these can be, many dozens of pages. And this may be, the first that the public really hears, and all that the public really hears in terms of what was the criminal conduct, what happened at the company, why did the company get into trouble, and that serves an important public function as well, given how rare it is for a corporate case, a case brought against the company, to actually go to a trial in the United States. There'll be some separate part of the agreement where lots of corporate officers sign, and the board may have to, there'll be corporate approvals. But again, whatever the label or the form of the agreement is, whether it's a deferred prosecution agreement, a plea agreement, even many non-prosecution agreements, they can be long documents with a lot of detail to them. Because they cover so many bases, all these parts of the document reflect some very different goals. If the goal was just to impose a fine that would punish a company, you wouldn't need to have all this discussion of statement of facts and compliance, and the agreement wouldn't have to last 2 or 3 years. You impose the fine, impose the appropriate punishment through a dollar amount, and then you walk away. If the main goal was to secure cooperation in figuring out who are the people at this company who committed these wrongs, we want the company's help to target them and to bring prosecutions of them. The agreements would also be a lot shorter. There would just be some statement that this company has substantially cooperated, and we're giving them credit for all the work they've done to help identify who committed these crimes. We're prosecuting those individuals, but we don't need to prosecute the corporation in the end. That would be a very short agreement too. If the goal was just to fix compliance, the agreements would be pretty long, but it would be all focused on compliance. There would probably be more monitors, and you wouldn't have all this stuff about fines or individuals. But instead, many of these agreements are trying to accomplish multiple goals at once, and their length and complexity reflects these multiple goals that prosecutors have in mind. Not only that, but these agreements shouldn't really even be viewed alone. They are often brought in connection with separate agreements entered sometimes on the same day with different regulators, which may have overlapping terms. Often in the US, it is the regulatory agreements that have even more detailed statements about compliance, changing procedures within the company. And certainly there may be additional payments, fines, and the like. The prosecutors may impose separate overlapping obligations, but there may be multiple agreements entered by multiple different authorities, hopefully negotiated in a way that they are somewhat consistent with each other and at the same time, but not necessarily. And so there's a lot of paper generated in these settlements. And if it's useful, the registry that I have makes it possible to search through all this paper and look for cases that involve foreign corrupt practices, or cases from 2008 where the settlement was more than $10 million, or cases from the Southern District of Texas or the Southern District of New York. And so cases involving companies incorporated in Japan, you can pull those cases using the registry. So I hope that resource is useful for you, and I really look forward to the conversation and to your questions.
So thanks, Brandon. Before we turn to Germany and Daniel, I just wanted to ask a follow-up question to Michael, and the preface is that, of course, all of this in the US flows intellectually from our long history with plea bargaining in our criminal justice system, and a practice that goes back a long way and over a century roughly has come to dominate individual criminal dispositions, but that shouldn't cause outside observers to make the mistake of thinking that the U.S. Doesn't care about trial litigation anymore just because we don't do much of it. We also don't do as much in the civil sphere as we used to, but I think we still in our legal system have the idea that litigation and trials is a way of developing the law, of establishing important public facts about what occurred. And some of the things that Brandon is talking about in these settlements are in a way kind of taking the place of that process, that we almost have developed a kind of, if you want to call it a sort of a case law of corporate settlements. You can go and look at these documents, right? And it's particularly the growing practice of including detailed statement of facts and more detailed explanations than there used to be of what factors the prosecutors actually put the most weight on in determining the terms of the settlement. The fact that Brandon and others are collecting these documents and making them available, it almost becomes kind of an informal body of law, right? So you could kind of see it that way, right? But my question for you, Michael, is that completely inconsistent with the way it's viewed in practice? I mean, are these things actually used in any kind of precedential way by lawyers who are negotiating with the government?
So it's funny that you asked that question, because for quite a while now, I have discussed what I refer to as prosecutorial common law, or the common law of settlements, because it takes on that feel. And I've done it in a sort of pejorative way for precisely the reason that you said, which is it lacks any sense of judicial oversight or judicial review. And it over time, I think, gets unmoored from the law. And it just becomes, what can the government get a company to agree to? And it, I think, is responsible in part for some of the Supreme Court decisions that have been 9-0 against the Department of Justice's interpretation of certain criminal laws. So you've got this dynamic where a company really doesn't care that much about the jurisprudence or the legal theory. They want to resolve the matter. They want to try to reduce the amount of the fine. They want to try to avoid a monitor if they can, because every time they do that, the uncertainty is removed and their stock price goes up. And so their incentive is very different from the Department of Justice's incentive, which may be to assert slowly more aggressive interpretations over time. And from the perspective of a client, you don't really care about that. But from the perspective of the law, I think the Department of Justice should. They often don't. And that's why the law gets expanded. Companies sort of go along with the DOJ's interpretation because they have no choice, until you get a well-funded individual defendant, a Jeff Skilling, a Conrad Black, who has the money and the resources and the incentive to go take a case all the way up to the Supreme Court, and the Supreme Court turns around and says 9-0, which doesn't happen often on the Supreme Court. No, DOJ, this is not what the statute says. And so I think from the jurisprudential perspective, it's highly problematic. But in terms of practice, unfortunately, that's what clients really have to pay attention to. If you look at the FCPA resource guide, it's almost all settlements, because there have been hardly any cases decided. I'm not sure that's a good thing from the perspective of the legal system.
But my question was also whether, take all of those points, but whether you're able to say, because there is this kind of, as you said, sort of common law of prosecutorial behavior now, and I realize, companies don't have a lot of leverage, but, you're a good lawyer, you try to get everything you can for your client. Do you go to the government and say, look, our case is on all fours with this prior settlement that you did, so this really ought to set the boundaries or the ceiling on anything that we're talking about here. Otherwise, you're being inconsistent, which, my experience, prosecutors don't like to be called inconsistent or unprincipled.
No, that's absolutely true. And as a defense lawyer, you take anything that can help you, arguing with prosecutors. But certainly, one of the things that prosecutors do want to try to do is be even-handed. And if you can point them, and whether it's resources like the one Brandon was talking about or otherwise, I mean, I've had plenty of situations where I've gone and told told younger lawyers, associates, go find me cases that are in this field that deal with these kinds of statutes, and just give me a sense of what the range is. So, in the first place, I can give my client a sense of what the possible outcome and range of outcomes might be, and also to be able to talk to the prosecutor if they've got a wildly different view of what the resolution should be.
Thanks. All right, Daniel, tell us what's going on in Germany. I can't wait to hear.
Thanks, Professor Buell. Hello, everyone, and a pleasure to be with you tonight, this morning, whatever the time is where you are. And also thank you very much to Daisuke for putting this very interesting and diverse conference together. So I'd like to start to talk a little bit about the current German sanctioning framework. On my first slide, you see sort of a differentiation between individuals and legal entities, and that is important because these systems are separate but also somehow interact. So although I will be focusing on sanctioning of legal entities, it's helpful to understand a little bit about the individuals side as well. For individuals, we have actually two bodies of sanctioning. We have the penal sanctions, the criminal law, and we have the administrative sanctions. On the corporate side, however, we only have, at this point in time in Germany, the administrative sanctions, i.e. currently there is no corporate criminal liability, and we'll see in a moment that this is something which is now on the wake of actually being introduced potentially here. Maybe an interesting point on the corporate fines, the ceiling for the fine itself is actually pretty low. So you'd have for criminal misconduct of employees, you would have a ceiling of 5 million euros for negligence and 10 million for intent. So you wonder, how on earth do you have those huge fines you lately read about in Germany? How does it actually come about? And the answer to that question is it's actually the profit disgorgement portion of the fine. So you can see the fine in essentially two portions. One is the penalty component, that's pretty low. It's capped at 5 or 10 million euros. And then you have a sort of a huge unlimited amount constituting a sort of a disgorgement component. So for example, in the recent Volkswagen case, which was I think the highest fine ever of 1 billion, you would have sort of a ridiculously low kind of 5 million amount of a fine, and the rest of the 995 million was the disgorgement component. Can we have the second slide, please? Great. On the pretrial resolutions as we have it today, we do already have a system which does, to a certain extent, embrace pretrial resolutions, which we can to a certain extent compare to the NPA, DPAs we've talked about today. Although technically speaking, it's not an agreement, but it's rather an order which the prosecutor eventually issues. But in substance, there is the ability you may have in the ongoing proceedings to actually engage with the prosecutor by way of cooperation, having discussions and actually influencing what at the end of the day will be the content of that order. So in a sense, it is also in a broader sense a negotiated instrument. So coming to the individuals, we have essentially two variations of pretrial resolutions. For the minor cases, one would have a sort of a termination of the investigations without any kind of payment or other obligation imposed on the defendants. Whereas in the more sort of serious cases, you would have court approval and then certain directions and conditions imposed, something like paying payment of money or taking a compliance training, things like that. That is the system for the individuals. Again, that is penal code, so that is not applicable on legal entities, but nevertheless, we do find similar mechanisms there as well. And the reason is that in the administrative sanctions regime, the prosecutors have a very broad discretion. So this broad discretion would actually include decisions of whether to investigate, whether to impose a fine, and if and how to end proceedings. So within that broad discretion, you can actually pretty much mirror what you have on the part of the individuals in terms of potential outcomes of a pretrial resolution, even though those sections 153 and 153A of the Penal Code do not technically apply, similar outcomes can be achieved. But nevertheless, given that this is not exactly prescribed in the law and very much a matter of discretion, it is an informal process and does require some experience to navigate. And I can say it does deliver significant advantages, or can deliver significant advantages to the client if you manage to actually come to a sort of consensual or quasi-consensual resolution with the prosecutor. And that not only and obviously relates to the amount of the fine, that's clear, but also maybe even more importantly, would also relate to the content of that decision, in particular to the facts which are set out. And we just heard a couple of moments ago that the statement of facts is an important element in the US system. It seems to me we have a little bit more flexibility here when we have the ability in a good cooperation situation to discuss orders with the prosecutor, in a sense that we try to convince the prosecutor that not necessarily every detail is required to substantiate the penalty, and we try to avoid statements of facts which later on can be picked up by the plaintiff's bar in the ongoing civil litigation, which usually comes sooner or later after we have a large criminal case. Maybe a couple of examples to give a little bit of a flavor how this worked so far in the German system before we move on to the potential new law we may have soon. I think everything started more or less with the landmark Siemens case in 2007, 2008, so significantly later than in the US, with a very high fine for German standards in the first instance around about 200 billion euros, in the second instance 395 billion euros, both cases corruption. Then we had a large corruption case with a truck builder, MAN. And then, of course, you may have recently seen or read in the press in the course of the diesel scandal, huge penalties, the one imposed on Volkswagen I mentioned earlier, but also 800 million euros for Audi and for Porsche to the tune of 535 million. So really significant amounts. And I would say this also shows a bit of a trend whereby there is a sort of understanding that in at least for corporations, the fine amount should be more significant than they were in the past. And again, this is being achieved by a rather complex instrument, being the profit disgorgement mechanism. Now, good. That takes us to slide 3, please. Now, I already mentioned earlier on that we have a new draft law on the table here. It's a Corporate Sanctions Act, as we call it. The history of it is it was actually intended originally to create a corporate criminal liability. That was thought to be inappropriate by many and was criticized strongly because it was felt that criminal liability is something necessarily attached to individual guilt, and it was seen as being difficult to actually have an idea of a corporation becoming criminally liable. So what we did, or what a legislator did, was to have apply a little trick. We now don't call it criminal liability, but we call it corporate sanctions. So it's in a way in between the administrative offenses and which we have now, and the sort of criminal penal code on the other hand. Although I would say the look and feel of it is much closer to the criminal side than it is to the existing world of the administrative sanctions. So let me talk maybe a little bit about the key principles and new elements that should be introduced. A major game changer will be that the prosecution authorities will no longer have this broad discretion they have now in the existing world where it is about administrative sanctions. But in the new world, prosecution will be mandatory. So in theory, at least that's what the law would say, each and every case, every suspicion would have to be picked up and prosecuted. The flip side of that is, however, that this mandatory prosecution can be ended with those pre-trial resolution instruments I talked about earlier, and I will talk about this a little bit more in detail in a minute. One other interesting point to note is that the scope of fines will increase tremendously for larger entities, meaning north of 100 million euro turnover. It will be 10% of worldwide annual turnover in case of intent and 5% in case of negligence. So that is a significant increase compared to what we have now. It's very hard to predict whether or not and how the law will be enacted. There's a lot of criticism and debate around it for many reasons. I'm afraid we don't have now the time to discuss in detail, but it certainly will be a big change if it comes. And I personally think after so many years of discussions and also the development, as I showed you a little bit earlier, with sort of, the sort of understanding in the prosecution community that corporations need to be treated in a stricter way, and you see the fines going up. So there's a kind of an atmosphere which I think supports imposing stronger fines, higher fines on corporations, and the increased focus also on criminal sanctions, I think will facilitate, and probably in some shape or form, I would think we will probably see that law coming to light at some point in time, perhaps with some modifications. That's possible. Can we go to the next slide, please? Thank you. So just to finish it off, maybe a couple of words and thoughts on how these pre-trial resolutions, or maybe if you want to call them NPAs, could work under the proposed Sanctions Act. As I mentioned earlier, the flip side of the duty to prosecute is that the statute now also provides for resolution options which are actually provided in the law, similar to those sections 1.3, 1.3a of the Penal Code I described to you earlier. There is a huge range or new also elements of conditions which can be imposed, retribution of damages, payments to the Treasury, of course, but also, and that is very interesting, the appointment of a monitor. That is a new element which we will have the new law becomes enacted, which obviously is directed against preventing future wrongdoing and facilitating the improvement and rectification of deficiencies in the compliance system which led to the relevant misconduct. The legal prerequisites is that, and this is shown on the slide, you need to demonstrate there is no prevailing public interest in actually prosecuting. It must be appropriate given the severity of the misconduct, and also you need the consent of the affected legal entity and of the court in most cases, except for very minor misconduct. So that's a very interesting development which we see here, and I think that this will probably lead, if it gets enacted, that we may probably see less of this very complicated profit disgorgement, which is extremely hard to calculate and establish for the prosecutors, and it will be in the future a much easier trail to just simply put a higher fine and forget about the profit disgorgement. If that is possible, if the numbers sort of support it. I don't think it will necessarily lead to an increase of the overall number of the fines, but it may. And it certainly seems that the law provides for an enhanced toolbox, which will make it more effective to prosecute corporations on the one hand, but also, and that's maybe a good thing from the perspective of the practitioner, will provide a more predictable path perhaps to the resolution than this very fuzzy sort of everything in discretion of the prosecutor system as we have it today. Thank you.
Thanks, Daniel. That was fantastic. I learned so much. I always struggle to understand even when it's very clearly explained, as you have, what's going on in Germany. This is a problem in comparative law generally, which is one often is unsure whether what one is confused about is simply the vocabulary, or that there is actually some very deep legal understanding that's just very different, right? And we actually haven't found the right vocabulary to understand each other. I always had this question about this administrative sanctions idea in Germany that, well, isn't it really not that different than what we do in the US, in the sense that maybe it's not called criminal, but you can't put a corporation in prison anyway. You can only impose financial penalties and other strictures and requirements. And of course, we have many civil regulators in the US system, the SEC, for example, who have the ability to do those things. And so then when people in the US system say, well, what is it that corporate criminal liability really does? Well, a lot of it has to do with the label criminal and some of the collateral consequences that can flow from that, the reputational effects, some differences in procedure, the ability to use the grand jury to investigate and so forth. But it's not obviously prison, which is the thing that generally distinguishes criminal justice in the US when we're not talking about corporations. So I guess I'm curious what are we really doing here if we have this Corporate Sanctions Act in Germany? Are we changing anything fundamental, or are we simply putting a different label on what was already kind of an available procedure, and then perhaps including some rules that allow for higher levels of monetary sanction?
Yes.
Or is there something institutionally going on here that we're missing in the story, that this would somehow be, these cases would be investigated and brought by a different entity with different kind of powers or something like that?
Actually, I think that there are a number of changes. I mean, on a very sort of high level, you could say, what's the difference if you pay euro as an administrative fine or as a sort of criminal offense or whatever? It's a euro or €1 million, whatever you have to pay. But I think if you look a bit deeper, there is a difference. I mean, there's certainly a difference in perception. I mean, I think the German law tends to be a little bit philosophic, I guess, more than the Anglo-Saxon system. So I think people truly believed it's inappropriate to treat, most severe corporate misconduct in the same way as, a parking ticket in the sense of moral, the moral level you're talking about. And that is, I think, a deeply felt sort of point about this. And even though it wasn't possible, as it seems now, to call it criminal law, at least it's something different than the parking ticket. So that's one aspect. And the other aspect, maybe more importantly, these cases will be treated now like criminal law cases with all the protections and rights, procedural rights you would have as defense counsel, attorney-client privilege, and the like, which is a bit different now in our existing system. And maybe thirdly, in Germany we don't have a DOJ. It's unfortunate, but that's what it is. So we have so many district attorneys, maybe you would call it, sort of scattered throughout the country. And most of these ladies and gentlemen, they would never in their entire career ever go after a corporation because they don't have the expertise and the time, maybe so many things to do, so many petty crimes to go after, and many individuals. They don't have the resources to do these sort of large scale, very sophisticated type of investigations as the DOJ or the other agencies would do. And in our system, we have some centralized agencies as well for antitrust and so forth, but not for corporate criminal sanctions. So there has been a huge difference in the activities in the criminal sanctioning sphere. So if you were lucky and your company was in Hamburg, maybe you never got bothered. But if your company is in Munich, unfortunately, you would definitely have a higher risk of being prosecuted, because just the Munich prosecutor and other large cities are much more sophisticated and are able to deal with those situations. So the hope, at least, may not be at the end, not really be fulfilled fully, but at least to a certain extent, making it now compulsory to prosecute corporations if there are any kinds of indications at least may have the effect, at least that's the intention, to create a more level playing field across the entire country. Yeah, so that's maybe some of the aspects which differentiate the potential new world from the existing world.
That's very helpful. I'd love to have a longer conversation with you about it another time. It's interesting, in the U.S. Literature on corporate crime, the point has sometimes been made that, well, you know, when you bring in all the procedural protections that are involved in criminal cases, it creates an additional kind of messaging effect for what it means when a criminal conviction is pursued and successfully obtained in the face of all of those procedural obstacles. Of course, the irony is, if we're settling everything in non-prosecution and deferred prosecution agreements, then there are no such obstacles and there's no such meaning. All right, let's hear a little bit about Japan now. Hiroki, the floor is yours.
Good morning from Tokyo. It's a great honor to be on the panel with distinguished panelists. Time is pressing, so I'll try to be quick. So first slide, please. Unfortunately, I have to admit that Japan has had almost no discussion worth mentioning so far as to how regulators and prosecutors can and should utilize pretrial agreements strategically to achieve socially desirable outcome. And only quite recently, the government, practicing law attorneys, and legal scholars have begun to tackle with the issue. So I'll talk about why it has been so. So next slide, please. So first, historical background. After World War II, Japanese criminal procedures switched from the continental European inquisitorial system to the Anglo-American adversary system. And indeed, the Allied occupation sought to foster a vigorous adversary system. And the Constitution of Japan of 1946 and the Code of Criminal Procedure of 1948 has many provisions embodying Anglo-American notion of adversariness. However, Japanese lawyers showed some antipathy against adversary system. Japanese lawyers thought the outcome of the process should not be dependent on the party's will. So to restrain adversariness, Article 1 of the Code of Criminal Procedure was drafted. It stresses that the purpose of the criminal procedure is to clarify the true facts. And the Code of Criminal Procedure requires all indicted cases should be adjudicated by trial, even when defendants pled guilty in the arraignment stage. So not only the contested cases, but also the cases where defendant pleads guilty should be adjudicated in the same manner. So next slide, please. However, Japanese criminal procedure allows prosecutors broad discretion in initiating or foregoing prosecutions and selecting specific charges. And the first, a threshold for the indictment in practice is beyond a reasonable doubt. And that means that is why the Japan's conviction rate is 99%. And even in the contested cases, the conviction rate is 97%. But even when prosecutors believe that the evidence at hand is enough to establish the guilt, they quite often chose not to charge. Statistics show that around 2/3 of felony cases with sufficient evidence are dropped by the prosecution. And defense lawyers do negotiate with prosecutors and try to persuade them to exercise their discretion to drop the case, usually pointing out such mitigating factors as regret, remorse, compensation, reputation damage, and voluntary rehabilitation efforts. And these voluntary rehabilitation efforts may include corporations' leniency approach. However, charging decision is solely up to prosecutors' discretion, lacking transparency and predictability. However, that didn't make defense lawyers to argue for introduction of more explicit, transparent plea bargaining law. And even around the turn of the century, aspiration for the whole truth and antipathy against bargain justice still prevails. And a prominent criminal law scholar described the Japanese feature of criminal justice as showed on the slides. And he stresses that the Japanese feature is zealous pursuit of the whole truth. And that notion is shared not only by prosecutors and investigators, but also by defendants. And next slide, please. And illustrative is that the 1995 Supreme Court ruling in the Lockheed bribery case. As you may know, the Lockheed Aircraft Company gave bribes to many foreign officials in 1970s. And that allegation includes the bribery of then Japanese Prime Minister Tanaka. And Japanese prosecutors wanted to get a testimony from then Lockheed's vice chairman and the head of Tokyo office. But they both resided in the US and they refused to testify. So Japanese authority asked a legal assistance from the US federal judge. And the federal judge agreed to conduct a witness examination, but as a condition, the federal judge asked the Japanese authority to grant immunity to witnesses. And at that time, we had no plea bargaining law or no grant of immunity law in Japan. So the confusion arose. But finally, the Tokyo's district attorney decided to grant immunity to witnesses. And the attorney general and the Supreme Court at the highest organ of judicial administration endorsed that grant. And the witnesses testified and the depositions were sent to Japanese court, and the district court and high court admitted these depositions to evidence. But when the case reached the Supreme Court 90 years later, the Supreme Court held that these depositions were not admissible. And the reasoning is showed in the slides, and I have to point out that the rejecting the denying the admissibility of the depositions, the court stressed that if Japanese law should adopt plea bargaining or immunity law, it must be a comfort with the notion of fairness, fair trial, and the people's feeling of fairness. So at the time, the Supreme Court thought that the immunity grant law would not be compatible with the people's notion of fairness. This is the situation at the turn of the century. But soon after that, the situation has gradually changed. Next slide, please. So first, Japan's competition law introduced a leniency program. It is really a kind of bargain justice in 2004, and it worked well. And last year, the parliament passed a new law to make this leniency program more flexible. And finally, in the Criminal Code of Procedure was revised in 2016 to introduce plea bargaining and the grant of immunity. This amendment took effect in 2018. Next slide, please. So basics of Japan's brand new plea bargaining law. First, it's applicable only to certain kinds of white-collar crime and gangster crime. And suspects and defendants should cooperate with the authority in investigating and prosecuting other offenders. Assisting conviction of suspects defendants themselves are out of the scope. And the new law was implemented to create an alternative to secure testimonies, thus easing too much heavy reliance on suspect interview and written statements. So this is this might be look strange, but the special panel commission to discuss this was convened mainly for discussing the ways to ease heavy reliance on suspect interviews. So the plea bargain law was introduced along with the expansion of the scope of the wiretapping law and the audio and visual recording of suspects' interviews. So the investigators fear that the audio visual recording might hinder effective interview. And so instead, they required another tool to get a testimony. And we have had just 3 cases so far. So Japanese lawyers and citizens are just waiting and seeing if the new law works well or not. The first case was Mitsubishi Hitachi Power Systems, and it involves a foreign bribery. And the prosecution get a conviction in the first instance, and the High Court approved that. And the case is now pending in the Supreme Court. And so it's a success for the prosecution, but the general public was reluctant to accept that first case because the in that case, the corporation cooperated with the prosecution to convict its executive who worked for the company's sake. So most people see that the this law encouraged the corporation to scapegoat its employees or executives. And the second case is Cars Gone's case, Nissan Motors. And this fits the original intention of the legislators, that is they vaguely thought that although there's no legal restriction, but they vaguely thought that this new law should work as a encouragement of whistleblowing. And indeed, the Nissan's case fits that notion, but as you may know, the Cars Gone fled away, and the case is suspended. So suspended. And the third case didn't attract much attention, and it's the company president misappropriation of the company's money for personal use, but the amount was only $327,000. So it didn't attract people's attention. So first case was a bit, most people feel uneasiness with the first case, and the second case is pending and suspended. So the Japanese lawyers, we think it's too early to judge if the new law is a success or not. So this is a Japan situation. Thank you.
Thanks, Hiroki. Daisuke, is it okay if we go till for another 10 minutes?
Sure, of course.
Okay, great. So that leaves us 10 minutes for question discussion. I'm going to start with the panelists. Is there anything, Brandon, Michael, or Daniel, that you want to say in response to Hiroki's presentation? If not, we'll go for audience questions. All right. I already see a question in the chat from Jennifer Arlen, so I'm going to let Jennifer restate that question verbally. And if anyone else has questions, please use the hand raise function. Jennifer, go ahead. Jennifer, are you there? All right. I will ask her question from the chat. I think this is for you, Daniel.
Yeah.
So the question has to do with how the new German proposal is imagining that compliance will be evaluated in the comparison to the standard that's in the UK Bribery Act.
Right. I mean, there I think we have a bit of a discrepancy between theory and practice. And the theory of it is that you do not have strict liability as in the US system. For everything the sort of employee on the lowest level would do in terms of wrongdoings, but you do have a system which in theory would only attribute a misconduct of employees which are below sort of senior management level to the corporation if there was a lack of oversight. And lack of oversight essentially means that you would need to satisfy that test. You would need to properly select and supervise and use qualified people, have proper procedures and so forth in place in order to demonstrate that your oversight was in fact okay. Now the problem with that is, and now I'm coming to the practical side, something did happen, right? Otherwise you wouldn't be talking about it to the prosecutor. And unfortunately, it's very hard to demonstrate that your systems and controls were super when something really bad happened. At the end of the day, it seems from a practical perspective, really difficult to actually demonstrate that you had proper controls and oversight in place once a prosecutor picks up a case and starts an investigation. So in my experience, at the end of the day, you would usually end up, paying a fine, which is more or less high, but you would very rarely succeed to convince the prosecutor that in fact your systems and controls were state of the art. So that's maybe theory and practice of it.
Yep. So Michael, how does that play out in the US system? Because obviously we've had a lot more of these cases than Germany, been doing this a lot longer. It's typical to have a very robust conversation with the DOJ about the quality of a compliance program. And of course, it goes without saying that you'd never be talking to the DOJ if something hadn't gone wrong. So you must have some success in the US of persuading prosecutors that there is such a thing as a crime in companies that have good compliance programs. There's no such thing as a perfect compliance program, right?
Yes, and over time, I think DOJ has recognized that and has started to incorporate that. There's the recent, actually, before the Trump administration, the fraud section actually had a permanent full-time position occupied by a former corporate compliance officer who was able to sort of, I think, really educate a lot of line prosecutors who don't come from a compliance background about what an effective corporate compliance program really is. Because you're right, corporate compliance programs clearly have not caught and stopped the conduct that occurred if you're talking to prosecutors. But given that, the Department of Justice has done much, much better lately at sort of laying out what the components of an effective corporate compliance program are, so that you can point to those specific things, show that your client has those things, and importantly, demonstrate how whatever it was that didn't let this get caught that time has now been fixed and improved, so that you know what went wrong last time and you fixed it going forward. And that can be a powerful argument to make to prosecutors.
So, Hiroki, a big part of this system as it's evolved in the US and is being mirrored in some respects in jurisdictions like Germany is a very involved process in which prosecutors are talking to companies about the details of how companies are going about managing themselves, particularly in the compliance space. I have a stereotypical impression that Japanese corporations are not used to having that kind of scrutiny, but maybe that's wrong. I mean, sort of in terms of the culture in Japan of the relationship between regulators and the corporate sector, is it harder for the government to kind of get companies to buy into the attitude that the government should have a say in how corporations are managed?
Well, if I may, can I invite Daisuke-san to talk about that? Because he's an experienced practicing lawyer, so he may be have a good knowledge about it.
Okay, thank you, Sasakura Sensei. So, yeah, since the originally the traditional the relationship between the Japanese investigative authority and the corporations haven't dramatically changed so far, but given that the activity of corporation has been international more and more, so actually companies have recognized to be global, and they recognize that, so they need to prepare for a good compliance program, the global level, and so in that trend has some impact on the relationship between corporations and the government. And one another factor is, as Sasakura Sensei mentioned, in the field of antitrust. So there's some globalization occurred, and they got really good knowledge about what government and the corporation have done. So in the field of antitrust. So and I think this kind of trend have gradually had some impact on the relationship between companies and the government. Did I answer your question? Oh, Sam, so you're now mute.
Sam, you're on mute.
Oh, I was muted. Yeah, everybody has to do that at some point on Zoom, is be the guy who forgot to mute himself, unmute himself. So I think that will conclude panel 4. Very interesting comparative discussion. I'm fascinated with the comparative issues in corporate crime. Jennifer and I just published an article on that, and I think are wanting to continue to work on these issues. It's kind of the new frontier, and it's going to continue to be really interesting to watch all these developments, and I hope these conversations will continue among us and others. Daisuke, thank you to all the panelists, and thank you to Daisuke for hosting, and I'll turn it back over to him.
Thank you, Sam,
Thank you.
and
Thank you.
speakers for session 4.